Welcome to Talk Testimonies. We're your guide through the sometimes complex world of Supreme Court decisions. We do the digging so you get the key insights.
And today we're tackling a really interesting one, New Prime Inc. v. Dominic Oliveira.
Yeah, this case was argued back on October 3rd, 2018.
And it zeroes in on the Federal Arbitration Act, the FAA. Specifically, there's an exemption in the FAA for contracts of employment for certain workers in interstate commerce.
The big question was, does that exemption also cover independent contractors?
Mm-hmm.
Or is it just for traditional employees?
Exactly. The court just below the Supreme Court, the First Circuit, had actually said, yes, independent contractor agreements could be contracts of employment under the FAA, meaning they'd be exempt from arbitration.
But that wasn't the final word. The Supreme Court stepped in and, well, they saw it differently.
They did. The Supreme Court ultimately concluded that the FAA exemption doesn't automatically cover independent contractor agreements just because they involve work. It's more nuanced than that.
Okay, so let's get into the arguments. How did New Prime, the company in this case, make their argument to the Supreme Court?
Well, New Prime basically argued that the First Circuit got it wrong. They felt that reading contracts of employment to include independent contractors just didn't line up with the law's plain meaning.
The plain meaning.
Yeah, the straightforward reading of the words. They also said it clashed with the FAA's structure, its overall purpose, the history behind it, the whole context.
So what was their reasoning on the actual words, like employment?
Their core point was that when Congress uses terms like employment or employee, without giving a special definition in the law itself, you should generally rely on the standard legal definitions, the ones from common law, which distinguish employees from independent contractors.
So New Prime was saying the FAA wasn't trying to rewrite the dictionary on what employment means.
Precisely. They argued the phrase contract of employment of a worker points to a traditional employer-employee setup.
And if it's a different kind of deal, like an independent contractor agreement,
then, in New Prime's view, it falls under the FAA, meaning disputes should go to arbitration, as the contract likely stated.
did they bring up other cases to support this?
Oh, yeah. They leaned heavily on a prior case, Circuit City.
Right, I remember that one.
In Circuit City, the court had said this specific FAA exemption should be read narrowly. New Prime argued this was intentional, to boost the FAA's main goal, promoting arbitration.
So a broad exemption would undermine that goal.
That was their argument. And they drew this interesting distinction. They said, contracts of employment isn't the same as the whole concept of an employee-employer relationship.
Also.
They suggested contracts of employment is narrower, referring specifically to formal employment agreements, not just any working relationship.
Okay.
And they cited Darden and Reed, two other Supreme Court cases, which basically said Congress usually means the ordinary definition when using words like employee.
They were really building a case based on standard legal interpretation.
Definitely. And they tackled the history, too. Some argued that back in 1925, when the FAA was enacted, the lines between employees and independent contractors weren't so clear. But New Prime said, not so fast. They pointed to legal books from that era, like one by Cunnington from 1920, that explicitly discussed the difference.
So they argued the lawmakers back then did understand the distinction.
Exactly. Their bottom line was contract of employment meant then what it means now, a traditional employment agreement, not just any agreement to do work.
What about the practical side? Like, who even decides if the exemption applies? The court or an arbitrator?
That was a bit of a wrinkle. Initially, New Prime sort of suggested maybe the arbitrator decides that too, based on delegation clauses in the contract.
Oh, okay.
But they later seemed to concede a court could make that initial call. Their main concern, though, was avoiding a whole separate trial just to figure out if Oliveira was really an independent contractor before even getting to arbitration.
They wanted to focus squarely on the contract itself.
Right. Just look at the agreement. Does it look like a standard employment contract on its face?
Even if someone argued Oliver's independent contractor status was, just a label to avoid labor laws.
New Prime acknowledged that argument, but said, essentially, that's a fight about the merits of the case. That's what arbitration is for, if the FAA applies.
And they also mentioned he chose that status freely.
They did put that out there, yeah. Their view was the FAA looks at the contract, the agreement between the parties, not necessarily the day-to-day reality of the job.
Interesting. They also said giving binding weight to the label independent contractor would be unusual, but argued the FAA specifically focuses on the contracts themselves.
Yeah, it was a bit of a nuanced point there, but ultimately they concluded that an agreement like this one between Oliveira's LLC and New Prime, especially one allowing him to hire others and work elsewhere,
Should clearly be subject to the FAA and its pro-arbitration stance.
that was New Prime's position.
Okay, so that's a pretty clear picture of New Prime's argument. Let's flip it. How did Oliveira, the respondent, counter all of this?
Oliveira's argument started from a different place. Their core principle was, you have to interpret laws based on what the words meant when the law was passed.
So back to 1925 again.
Exactly. And they presented historical evidence suggesting that in 1925, the term contract of employment was actually used much more broadly.
More broadly, how?
Well, they argued it wasn't just limited to common law employees. It often encompassed agreements for work generally, including what we'd now clearly call independent contractors.
Did they have specific examples?
They did. They showed instances where Congress itself, in other laws from that same era, used contracts of employment when talking about agreements with independent contractors.
Wow, okay, so Congress itself used the term that way.
That was their claim. They argued most sources from the 1920s used the phrase inclusively, suggesting that was just the common understanding.
So under Oliveira's view, the FAA exemption for that class of workers in interstate commerce
It should apply to anyone fitting the description of a worker engaged in that commerce, whether they're an employee or an independent contractor. They argued worker itself is a broad term.
And they also looked at Circuit City, right? But from a different angle.
Right. They focused on the part where Circuit City mentioned the exemption might have been there to avoid conflicts with older labor laws.
Okay.
Oliveira argued those older laws often defined coverage based on the type of work someone did, not their formal classification, like, say, railroad workers.
So if the FAA exemption only applied to traditional employees, it could actually clash with how those other laws work.
That was their reasoning. It would create the very conflicts Congress supposedly wanted to avoid. They used the Transportation Act's definition of railroad employees as an example, which focused on the work performed.
Makes sense. They also drew a line between individual workers and companies, right?
Right. A very important distinction, yes. They stressed the exemption is for workers, individual people doing the work, not for, say, the trucking company itself. The focus is on the individual human involved in interstate commerce.
And this tied back to the procedural point, who decides?
Oliveira argued strongly that a court must first decide if the FAA even applies before sending anything to arbitration, especially if the contract might fall into an exempt category.
They pushed back on the idea that courts could just pause the case indefinitely.
Yeah, they argued courts have a duty to exercise the jurisdiction they're given, and putting cases on hold like that isn't the standard procedure unless there's another active legal process.
So how would the court figure out if it's an individual worker? Did they suggest a mini trial?
Not necessarily a full trial. This suggested it could be a more summary process, maybe looking at sworn statements or declarations. The key question, they argued, is whether the agreement was for a specific person to actually do the work.
And this could include legitimate independent contractors.
Yes, under their view. If you're an individual worker performing transportation work under an agreement, even a valid independent contractor agreement, you could fall within the exemption. The focus is on the worker's agreement to work.
What about New Prime's point about the historical sources distinguishing the two roles?
Oliveira's team said, we found sources too. They claimed they cited plenty of materials from the 1920s, even a book on independent contractor law that did make the distinction, but still used contract of employment broadly.
So their argument kept circling back to that 1925 meaning.
Absolutely. The ordinary common understanding back then, they argued, covered all agreements for transportation workers to perform work.
They also addressed a tricky hypothetical, didn't they? About what happens if a court does find someone is an independent contractor for FAA purposes.
Right. They clarified that even if a court decided the FAA exemption only covers employees, and then found Oliveira was not an employee for FAA purposes, that finding wouldn't stop Oliveira from later arguing he was an employee under, say, wage and hour laws like the Fair Labor Standards Act.
Because the legal tests are different.
Exactly. The definition of employee isn't the same across all laws.
And one last point, did they challenge New Prime's focus on just the contract's text?
Yes, they argued that none of the sources New Prime cited actually said you only look at the contract. They suggested that the reality of the working relationship should also be considered, especially if it contradicts the contract.
Okay, that lays out the two sides very clearly. Now, let's shift gears a bit. If we were putting on a metaphorical 10th justice robe, how might we think through this?
It's a fascinating exercise. I think the historical context just jumps out, doesn't it? That 1925 meaning of contract of employment.
It really does.
Yeah.
If the common understanding back then was broader, as Oliveira argued, well, shouldn't that guide the interpretation?
You'd think so, especially when you layer on that idea of avoiding conflicts with other existing laws from that time, laws that maybe focus more on the function of the worker, not just the label.
Right. While we absolutely have clearer legal lines today between employees and independent contractors, the job here is to figure out what this specific law meant then.
And the evidence Oliveira presented about contemporary usage, even by Congress, it seems pretty compelling that the term was more flexible back then.
There's also a practical consideration, isn't there? If you interpret the exemption super narrowly, relying only on the contract's label.
It could potentially create a loophole, right? Where companies might misclassify workers specifically to ensure arbitration under the FAA, even if those workers were the type Congress might have intended to exempt.
Yeah, and while promoting arbitration is the FAA's goal, you have to ask if Congress intended that goal to potentially steamroll other worker protections or exemptions that existed or were understood at the time.
It seems unlikely. So putting it all together, a reading that aligns with that 1925 common understanding one where contract of employment could include agreements where an individual transportation worker performs the work, regardless of the modern label.
That seems most consistent with the original intent and the historical context.
It certainly feels like a strong possibility from this 10th chair perspective.
That wraps up our deep dive into New Prime Inc. v. Dominic Oliveira. We've walked through the petitioner's arguments, the respondent's counter-arguments,
Explored that crucial historical context, and even donned our hypothetical 10th justice robe for a moment.
It's a case that really underscores how interpreting laws, especially older ones, isn't always straightforward, and how historical context is just vital.
Absolutely. And how those interpretations continue to affect very real modern work situations.
We really hope this breakdown has given you, the learner, a solid grasp of this significant case and its implications without getting lost in the weeds.
And it leaves us with a thought, perhaps. When interpreting laws written generations ago, how much weight should we give to the original understanding versus the realities and evolved language of today?
That's definitely something to chew on. Thanks for joining us for this deep dive.